Good morning, everyone. On behalf of the Constitutional Law Club, I am delighted to welcome you all to our fourth expert lecture. Today, we have the privilege of hosting Professor Gary Jacobson, who will be speaking on constitutional identity and comparative constitutionalism, lessons from philosophy and beyond. Professor Jacobson is one of the foremost scholars in comparative constitutional theory and holds the distinguished position of the H. Malcolm McDonald Professor of Constitutional and Comparative Law at the University of Texas at Austin. His works, Constitutional Identity, The Wheel of Law, and Unconstitutional Constitution, among others, have deeply influenced how constitutional identity, judicial review, and constitutionalism are studied and understood worldwide. Please note that we will be having a short interactive session following the lecture. However, before beginning, I would like to extend a very warm thank you to Professor Jacobson for joining us today, especially considering that it must be quite late in Austin. We now invite Professor Jacobson to begin. Thank you.
Well, thank you very much. It's a pleasure to be here, as it were. So I'm going to be speaking about India as a kind of a constitutional case study in identity and revolution. And in fact, of course, India provides fertile ground for constitutional theorizing about identity and revolution. In what follows, two stories can be told, but I want to begin with just 5 quick general points about identity and revolution. First, all constitutions develop over time in the sense that their meaning and identity evolve gradually. Their identity is shaped by a dynamic driven by their internal tensions and contradictions and by their confrontations with the social order over which they have limited influence. So disharmony, as I've argued in many places, is the key to constitutional identity. Now, second, constitutional identity is not some essence embedded in a society's culture requiring only to be discovered. Rather, identity represents a mix of political aspirations and commitments that are expressive of a nation's past, as well as the determination of those within the society who seek in some ways to transcend that past. Third, a constitutional revolution occurs when there is a major displacement in the way constitutionalism is experienced in a given polity. Such a transformation will be accompanied by critical changes in constitutional identity, although not every mutation of identity will entail a shift of sufficient magnitude to be considered revolutionary. Fourth, revolutionary discontinuities can take a variety of forms, ranging from the embrace of new constitutional arrangements to the textual or interpretive reordering of long-standing expectations about how matters of constitutive import are to be resolved. In some cases, this will unfold incrementally without the benefit of dramatic rupture, the kind of rupture that one has come to associate with revolutionary activity. In other words, violence need not be present when we're talking about a constitutional revolution. Fifth and finally, a nation's constitutional identity may be imbued with revolutionary significance, yet once established, it quite naturally mutates into the focal point for resistance to radical change. The classic example here is Germany. Now, the static and dynamic dimensions of this revolution identity relationship are the principal focus of my remarks today. The Indian Supreme Court followed Germany by, in effect, arrogating itself a supervisory role over any codified change that threatened regime essentials. So with conviction, it memorably declared, and I quote, The Constitution is a precious heritage. Therefore, you cannot destroy its identity. That, of course, is from Kesavananda. Now, Germany has its eternity clause. In India, there is no such clause in the Constitution, but over time there has developed, as you know, of course, the basic structure doctrine. European courts have been instructed by these Indian developments. These constitutional courts effectively embrace that. But in India, the basic structure doctrine, imbued originally with a preservative significance comparable to Germany, has taken on a transformative meaning consistent with Nehru's insistence at the Constituent Assembly that, quote, the Constitution was meant to be a dynamic constitution. In Indian constitutional thought and practice, at least as originally conceived, the commitment to identity as a barrier to radical change was eventually adapted to the reconstructive aspirations of the model. As was pointed out in the Supreme Court opinion, notable for its serious engagement with the idea of constitutional identity, and I quote, "We were enjoined," the court said, "to roam the high seas until we achieved a state of acceptable achievement of revolutionary goals, neither knowing the length of time nor the length of that journey." Now, the developmental path of the basic structure doctrine requires some reflection on how we might imagine revolutionary change within a constitutional context. And here again, Nehru's voice from the Constituent Assembly must be heard. The whole purpose, he said, behind the Constitution, which was meant to be a dynamic constitution leading to a certain goal step by step, is somewhat hampered and hindered by the static element being emphasized a little more than the dynamic element, and we have to find out some way of solving it. The transformative possibilities of basic structure jurisprudence are intelligible only if the purpose alluded by Nehru is given. This entails viewing the Constitution as a potentially subversive presence in the social order, leaving the institutions of civil society vulnerable to a document deeply antagonistic to the status quo. Now, most constitutions, of course, are not subversive. They're not confrontational in the sense that they are not designed to challenge the social order within which they are situated. That's not the case for India. But matters, of course, are not so simple. In India, there are two powerful claims on constitutional identity, both firmly rooted in centuries of conflict and contestation. Since independence, one of those claims for a secular composite culture nation has been in ascendance, but the other, for a Hindu nation, has influenced the aspirational content of constitutional identity. At times, it has posed a distinct threat to the supremacy of the predominant view. The identity that has emerged from this extended, disharmonic history reflects the entrenched realities of both visions. That's not, of course, to say that these entrenchments have been equally grounded in the document. Now, here's one story that follows from this disharmonic picture. In this telling, inherent in the Indian constitutional condition is an undeniable gap between foundational ideals and existing realities, and the constitutional obligation of the state to resolve the severest of these contradictions. As Nick Robinson has astutely pointed out, in essence, the Indian Constitution attempted to create an ongoing, controlled revolution by laying an architecture in which massive social and economic transformation could take place within the limits of a liberal democracy. So how did the identity entrenching basic structure doctrine evolve into an instrument of revolutionary prominence? The answer lies in the very incompleteness of the constitutional revolution that marked the inception of independent India. To the extent that the concept of basic structure is assigned a meaning that encapsulates the aspirational content of the social revolution that Nehru and others saw as the whole purpose of the Constitution, its deployment by the court has a dynamic component to it focused on the constitutional revolution's steady and continuing realization. Now, the most visible constitutional expression of the aspirations that stamp this document with a distinctive identity is to be found in the directive principles of state policy. The Constitution is explicitly and implicitly an affirmative action constitution. And the great challenge of Indian constitutionalism is to deliver on the promise of its transformative aspiration. That requires a court performing more ambitiously than in the familiar naysaying role of the orthodox judicial review model. The key case in this story, in this account, is Bomai versus the Union of India. The principal result, as you may know, in Bomai was the approval given to the dismissal of 3 elected governments deeply implicated in the violence associated with the destruction of a mosque. Yet the broader meaning of the decision may be found in the connection drawn in some of the opinions between the basic structure doctrine, specifically as it relates to secularism, and the responsibility of the central government to advance the constitutional essentials of the polity. Quote, secularism is more than a passive attitude of religious tolerance. It is a positive concept of equal treatment of all religions. Again, affirmative action. As one prominent commentator has said, Bomai made secularism impregnable against majoritarianism. It was, quote, a warning to the Hindu right and organizations that entertain the idea of a majoritarian Hindu state that any move in that direction towards constitutional amendment would be considered a violation of the basic structure of the Constitution. The court, in effect, was liberating the center to be a proactive player in fulfilling the aspirations that the court, had certified as high priority goals. Of course, the attainment of these goals rests on whether the government in New Delhi is supportive of these constitutional goals and agenda. Ideally, it would mean that governments, even those that may not have been complicit in actively working to undermine constitutional provisions, would henceforth be required to expend resources to advance ends that the court designates as necessary to further constitutional identity, and with it, the achievement of the constitutional revolution. A lesser known case, Indian Medical Association versus the Union of India, decided 2 decades later, underscores what's at stake. In this decision in 2011, the Supreme Court affirmed the constitutional logic, that's what it said, the constitutional logic that holds state intervention in support of constitutionally prescribed revolutionary goals to be a categorical imperative. Those words by the court. At issue was the policy of admissions to higher education. The policy was challenged on the basis of a Delhi law that mandated admissions consistent with the constitutional directive to secure the advancement of socially and educationally backward citizens for their entrance into both public and private academic institutions. The court was asked to declare this Delhi Act of 2007 unconstitutional, but this meant also addressing the validity of the 93rd Amendment to the Constitution, under which, in Clause 5 of Article 15, under whose authority the legislation had been enacted. Specifically, the court was invited to rule on whether the amendment of 2005 was unconstitutional as an abrogation of the basic structure of the Constitution. The justices used their invitation to deliver their most extensive elaboration of the concept of constitutional identity since the decision in Kesavananda nearly 40 years ago. The court's bottom line was unequivocally stated, quote, "We find that if we were to nullify Clause 5 of Article 15, we would have set ourselves on the path to ineradically alter the identity of the Constitution." The 93rd Amendment's insertion of that clause in the Constitution advanced, the court argued, the broad egalitarian objectives of the Constitution, and in so doing satisfied, quote, "the theory of basic structure which is based on the concept of constitutional identity," end quote. In so declaring, the court relied on Bomai. In the context of the long revolution, the 93rd Amendment may be viewed as a stride toward the fulfillment of the constitutional revolution's promise. The court's insistence that through the amendment, quote, "the goals and objectives that inform the constitutional identity applied to the private sector," and that only underscores its dynamic approach to the identity revolution question. Providing constitutional legitimacy for greater access to higher education to the weaker sections of the population pursues the transformative directive of the principles of state policy, as outlined in Article 46, to promote the educational advancement of lower status citizens. Upholding the amendment on basic structure grounds was a calculated effort to give fuller meaning to what was at best only an inscribed embrace of revolutionary constitutional identity. So that's one account. That's one story. But a disharmonic constitution can produce a very different story. The concept of identity is amenable to multiple agendas, including ones that may advance goals very different from what I have just discussed. Much as constitutional identity can be invoked to preserve liberal democratic ideals, it can equally serve the interests of those who aspire to very different ends. This is most glaringly evident in Hungary. When in Hungary, identity is used against the European Union. The concerning problem of democratic backsliding has been exacerbated through a conceptual distortion that enables its proponents in Hungary and India, and increasingly in the United States, to advance their illiberal, exclusivist objectives. And that's the second story. To be very direct, in India, the idea of a dynamic constitution supportive of egalitarian social change may be ominously giving way to an ethnically inspired populist reaction against further revolutionary progress. As Christophe Jaffrelot, perhaps the leading student of Hindu nationalism, has pointed out, quote, "Populism here appears as a form of counter-revolution, an antidote to the politics of equality." This conservative revolution, he says, has an authoritarian dimension as well. So much as in Hungary, where anti-Muslim Christian nationalism has enabled a phenomenon of democratic backsliding, the ascendance of a political movement in India dedicated to a Hindu nation threatens the constitutional experiment in democracy. The paradox in all of this is that constitutional democracy incorporates a commitment that necessarily muddies the waters of identity, namely democracy itself. Elections matter, particularly those having implications for the adjustments and modifications that accompany the progression of a nation's constitutional identity. The outcome in the 2014 elections, and I quote again from Jaffrelot, entail nothing short of an attempt to roll back the long social revolution. Speculation about a counter-revolution reminds us that commitments widely imagined as firmly entrenched possess a more contingent quality than may be commonly assumed. In relation to the dynamic components of identity, a major displacement in political power can affect the relative standing of competing strands within this disharmonic constitutional order, and thus reconfigure the shape of constitutional identity. Consider the outcome in the long-running Ayodhya dispute, which, according to Jaffrelot, signaled the officialization of Hindu hegemony over the Indian state under Narendra Modi. The result looks to be a significant data point in the recent counter-revolutionary embrace of a decidedly authoritarian politics. Formally, it legitimated a second-class citizenship status for Indian Muslims, and informally, it deflected popular attention away from the structural inequalities whose abolition had been at the core of the secularist vision of constitutional identity. Or, as Jaffrelot argues, the way the Ayodhya case has been dealt with over the last 30 years shows that some judges have gradually shifted away from secularism. The ruling in 2020, he maintains, was biased in favor of the majority community. It, he says, physically obliterated a phase of Indian history and a facet of India's identity. Let me now focus on this majority question, which has come to be known as, at least here and perhaps where you are as well, under the rubric of identity politics. An all too familiar touchstone in the story of democratic regression has been a carefully nurtured claim of majoritarian victimhood. This has meant, in the language of a famous American Supreme Court footnote, that, quote, the operation of those political processes ordinarily thought to be relied upon to protect minorities currently consigns them to the margins of societal concern and recognition. I'm referring here to the 1938 Caroline Products case, which includes the most impactful footnote in American constitutional history. It's known simply as footnote 4. In the third of the footnote's famous paragraphs, the justices called for a more searching judicial inquiry when reviewing statutes that were allegedly tainted by prejudice against those who belonged to what they labeled discrete and insular minorities. To be so recognized, a group would need to show that its members' rights could not be secured through, quote, the operation of those political processes ordinarily thought to be relied upon to protect minorities. What this in essence meant was that it would be necessary to establish to a court's satisfaction that there was something about the group that would deprive it of a fair hearing before a lawmaking majority. To the best of my knowledge, the term identity politics had not yet been invented, but a strong case can be made that its genesis, at least in a legal context, is traceable to the four corners of footnote 4. But identity politics has come to mean something quite different from what was intended in that footnote. In the ominous developments that sometimes go under the heading of democratic backsliding, a ubiquitous transformation has emerged. Political actors in multiple countries have embraced the concept of identity to advance an exclusionary agenda, an agenda at odds with the political dynamic that inspired its early proponents. Often these actors include judges whose rulings offer legal cover to others in the political arena. The familiar version of identity politics is driven by a felt need to counter a majority culture's domineering denial of minority group self-determination and recognition. But the legal narrative that we find increasingly associated with democratic decline is best understood in reaction to this, namely as a grievance-generated, constitutionally framed invocation of majoritarian identity politics. Now, the Indian Constitution contains, as I've mentioned before, multiple entwined threads reflecting the society's rich diversity as well as the numerical superiority of the Hindu majority. In the last decade of what to some looks like increasingly authoritarian drift, Hindu nationalism has risen to political and legal prominence at the expense of the nation's minorities. This recent history shows what can happen to a constitutional identity when, to achieve a desired outcome, in this instance, the ethno-cultural rendering of Indianness, political actors create a suspect narrative featuring a negation of disharmony. The result, a nationalism that is, in the spot-on formulation of my friend Pratap Mehta, quote, the most potent form of identity politics. During this time, the Indian Supreme Court appears to me to have come under the sway of governing authorities. Though, to be fair, its independence has not been compromised, certainly to the extent that distinguishes its counterpart in Hungary. While its rulings are often in sync with the government's priorities, its most controversial, consecrating Hinduism as the essence of Indian nationhood, had already been set on its ascendant path at least 20 years prior to Mr. Modi's coming to power. Wittingly or unwittingly, the judiciary had become a decisive enabler in reconstructing the foundational blocks of Indian secularism. Nehru's vision of an inclusive, composite secular polity may have been the early dominant strand in Indian constitutional identity, but present from the outset was a powerful, if subordinate, strand of cultural nationalism. It became less subordinate following several related judgments in 1995 concerning an official ban on making sectarian appeals in elections. In these cases, and I adverted to it in the piece that you may have read that I sent, in these cases, the Supreme Court, while invoking politically liberal ideas, blurred the distinction between religion and culture, equating Hinduism, and I quote, with the way of life of the people in the subcontinent. Why they did this remains, at least remains to me, something of a mystery. Fast forward 20 years and enter the Modi government. One of the contested speeches debated before the court in 1995 had included language that would become commonplace in 2014. Said the speaker, quote, "We are fighting this election for the protection of Hinduism. Therefore, we do not care for the votes of Muslims. This country belongs to Hindus and will remain so," end quote. The terminological blurring at the earlier date became a clear ideological expression of extreme nationalism 2 decades later. In the Prime Minister's now familiar and unequivocal rendering, quote, "The cultural identity of all Indians is Hindutva, and the present inhabitants of the country are all descendants of this grand culture." Of course, among the present inhabitants are millions of people whose identity has been largely shaped by their religious affiliations with groups other than the Hindu majority. Among these are a Muslim population, most of whom have been relegated to second-class citizenship. While hardly a discrete and insular minority, they are, as you know better than I, the frequent targets of horrific vigilante justice, as well as the more legally sanctioned ways by which the status of otherness is conferred. To cite just one notable recent example, the court's repeated reluctance to stay implementation of the 2019 Citizenship Amendment Act, CAA, arguably the most discriminatory law ever enacted in India. Its seeming violation of the constitutional principle of universal equal citizenship would, at an earlier time, in the context of the first story, have been quickly held to be a negation of the court's basic structure doctrine and therefore a challenge to Indian constitutional identity. Which leads me to this tentative conclusion about what's happening on the subcontinent. As in Hungary, a constitutional counter-revolution is underway. We see again the judicially abetted transformation of identity politics with its reimagining of constitutional identity. And of course, as I said earlier, by revolutionary, I mean here something very specific, namely a profound change in the way constitutionalism is experienced. And in both cases, in Hungary and India, that change is traceable to a rejection of disharmonic complexity in favor of a simplified, historically rooted grand culture. Now, such is the power of political manipulation that this counter-revolution might well have proceeded without the assistance of a supine judiciary. Still, the pre-Modi court in effect provided a permission slip to radically reconceive the basics of secular identity. And so controversial rhetoric from on high could be henceforth imbued with a patina of constitutional legitimacy. Let me return in conclusion to that iconic footnote that I mentioned earlier. It's worth noting that in both Hungary and India, where the movement towards authoritarianism has attracted mounting attention, the courts have largely abandoned the logic of footnote 4's second paragraph. This is the section which argues that the exercise of judicial review by unelected officials requires imagining judges as advocates, as in the first story, for enhanced access to the structures of democratic influence. For those harboring illiberal ambitions, the rejection of this role cannot but expedite the fulfillment of their aspirations. Finally, if comparative constitutional scrutiny teaches us anything, it is that a governing alliance's efforts to diminish the power of the judiciary will be cast as a defense of democratic self-government. In this respect, it echoes a populist-inspired argument very much in line with what we are today seeing in many places. Thus, the deference extended by the courts in Hungary, India, and the United States to majority-inflected outcomes is sustained by a common view that sees democratic well-being prevailing when the presumed will of the people is accommodated. The propagation of an us-them view of what that democratic will looks like in the end targets the very essence of democracy rightly understood. My last thought, though, is to caution against the idea that we must look to the courts to save our democracies. And I mean this for your country and my country, both of which are under this stress at the moment. As a distinguished American judge, Leonard Hand, once wrote, quote, "This much I think I know, that a society so riven that the spirit of moderation is gone, no court can save. That a society where that spirit flourishes, no court need save. That in a society which evades its responsibility by thrusting upon the courts the nurture of that spirit in the end will perish." Thank you.
Thank you, Professor. I guess we can take rounds of questions. I want to ask before so, we all agree with you that elections are important with relation to the Constitution. But we do not know on what issues people are voting. And we don't know if people even want a Constitution.
I'm having trouble hearing because there's some kind of a static.
So is my audio clearer now?
Okay, that's better.
Yes, sir. So elections are important with relation to the Constitution, but we don't know on what issues the people are voting, and we don't know whether they even want a constitutional revolution.
So I want to know when you believe we can say that the people have turned their back on certain constitutional principles, or how many elections would it take to understand that a people or a society no longer believes in certain principles. We've already seen 3 elections where the current government has formed a government, even though they don't very outrightly believe in some principles of the constitution.
If your question is how long does it take for this transformation in identity to occur following an election, I don't think one can assign a particular length. As I mentioned at the outset, quoting Nehru, the idea of the revolution itself, in its aspirational form towards greater democracy, is a step-by-step process, he said, that the dynamic aspects will always be hindered by, if not checked, by the more static elements in the society. And therefore, what others have called a long revolution is what ultimately results. The mere fact that the Constitution may establish in its language what these aspirations are does not indicate how long it will take to reach fulfillment. The same can be said, to your question, with regard to what might be called the constitutional counter-revolution. Now, what I suggested by citing 2014 as a moment of particular significance, because it was, after all, a national election, I also suggested that the preconditions for what culminated in that outcome in 2014 had already been established. That the court, in fact, was one of the components of that preview in 1995 when it conflated the idea of Hinduism and Hindutva. To the extent that that was already a reflection of a popular mindset, I cannot say. You would be better in a position to understand that. But surely in 2014, that sentiment, which was part of the campaign, was, if not, as you put it, clearly the mandate of what arose out of that election. It was part of that result, which then culminated increasingly in a much more decisive dedication to these more static principles in which identity can now be established not in the ongoing aspirational achievement of a particular democratic egalitarian idea, but rather in the affirmation of a grand cultural phenomenon that can be recovered. As I pointed out, constitutional identity is not an essence to be excavated from history, but in fact, increasingly that is what has occurred. It's occurring in the United States again as well. Make America great again is just another way of saying that there is a moment in our past when we can establish what the meaning of Americanness is. And the parallel to that, I think, is going on in the other nations that I used it as an example, both in Hungary and arguably in India. But this has not been settled, as your very acute question suggests. It is at best an ongoing and very inchoate process.
Thank you, sir.
Thank you. Sir, currently I have a question now. Can you hear me? Can you hear me, sir? Hello. Can you hear me now? Hello.
Yes, yes, I can see the top of your head.
Also, can you hear me now?
I can hear something.
Give me a second. Sir, I just have a question on something with regards to judiciary that you have talked about. So basically, from my own research on judicial review as a thing, I've found Indian judiciary to be locked itself into the epistemic thing or the relics of the colonial legacy. And if you go time back in 1950, we had a case like A.K. Gopalan, where we said Article 21, which is the liberty is not a thing. And even if we fast forward to something around 2017, we had a case like Navteet Singh Zohar, where we had a ruptures with the moral principles of the society, God, and when we had something like Super Now, though courts have been doctrinally rich in changing transformative constitutionalism, but I still feel they hesitate when there is something to be done with the society as a principle. And something like the secular principle, again, time and again has been something which has been clashing with the idea, the society principles.
I'm sorry, I didn't quite get the question.
Uh, can you hear me now properly?
I'm having difficulty
Maybe
hearing.
maybe Kabir can ask his question. Meanwhile, I'll type and send it. Kabir had a question to ask. Yes, Kabir, you can.
Yes, it was a slightly longer question, so I've typed it in the chat if Professor can see.
I'm sorry. I can't hear anything.
Sir, he has typed it on the chat. I'll read it for your convenience if you can hear me now. Hello. It's a slightly longer question, so I typed it on the chat. Can you open your chat box to see them? Hello. Do you want me to read them? Kabir, I guess you can read it out. I guess he's not able to access.
Sir, can you hear me?
I'm trying to, yes.
So the question asked is, constitutional morality as a concept is something that comes to mind when I hear your theorization of constitutional identity. The virtues that the former upholds or is supposed to uphold has also been said to be a cornerstone identity feature of the document. However, something that I have again noticed is that constitutional identity as a concept or theory can be very versatile. Would you say that constitutions should be able to regulate the kind of identity people want to form? In turn, should constitutions be able to regulate morality?
So should the Constitution be able to say that again?
Should constitutions be able to regulate morality of the people?
Should the Constitution be able to regulate morality? Well, the founding father of the Indian constitutional, the James Madison of the Indian constitutional, Dr. Ambedkar, actually used that terminology of constitutional morality. And in effect, as I can't quote exactly what he said, but he said that as we transition into an independent constitutional republic, we have to develop a constitutional morality. Now, a constitutional morality, which is, as I understand that at least, the experience of constitutionalism as a universal aspiration, is something that has to be ingrained in a people that is newly conversant with these ideas. That takes time. That's distinguishable from what I understand at least part of your question to be asking. A constitutional morality does not mean that the Constitution dictates to you what your moral ideas must be with regard to your daily behavior. Indeed, constitutional morality uh, um, of the kind that Ambedkar was talking about is one that is open to very different ideas of what moral principles should be followed in one's personal lives, as long as that does not interfere with the same pursuit of others dissimilarly situated. So, to the extent that we have moved, arguably, to a point where Indianness is not understood in terms of that Ambedkar constitutional morality, but rather a morality whose content is filled by a particular ethnocultural meaning, then constitutional morality, at least as aspirationally understood early on, has been undermined. I'm not sure, is that okay?
So there's another question. I'll just read it out for you. Uh, so basically, my research so far has been on judicial review, where I have.
I'm sorry. Could you start again?
Yes, sir. So I've conducted some research on judicial review, where I have seen the Indian courts so when ruptured with the moral principles of the society, it has been locked into colonial identity and epistemic lock-in. We have seen something like A.K. Gopalan in 1950, just a year into the operation from independence. Then we move forward to recent times where we have instances like the case in Navtej Singh Johar, where the court took into transformative constitutionalism. But in 2023, they restrained themselves to legislative deference while dealing with the recognition of same-sex marriage. So I believe it is also a larger trend in the judiciary and not just in restriction to secularism.
I didn't catch all of that. The the rulings on same-sex marriage have evolved over time, and there have been contradictory ones. To the extent that there has been an embrace of the idea, I think it remains, as it has become in the United States, a part of that sort of libertarian strand in the document that is always in competition with a more, what shall we say, communitarian or authoritarian view. But I probably do not know enough of about those cases to be much more specific, and I'm not sure that I heard the question entirely. So
That's it from our side, Professor. Thank you for joining us late in the night. And I guess it's around 10:30 in your time. And your analysis of constitutionality across different countries and jurisdiction, and especially when it's placed in the contemporary context, was really meaningful. And we all had a great time interacting with you and listening to you. Thank you so much.
thank you. A pleasure to be, even though it's very late here, it's been a pleasure to be with you.
Thank you so much, Professor. And if you're anytime around in India, New Delhi will be happy to host. Thank you.
Thank you.